Disclaimer, disclaimer, read all about it.
Gone somewhere and dyed my hair now. Wanna be alone. It's much to bear and you don't care, and I won't play alone. I got you in my sight. I keep all the words you said to me. I get you, get you, get you, get you on your knees. Rewrite all the things you said that I should be. I'll get you, get you, get you. Now you'll beg me, please. Hey.
Hey everybody.
Hey everybody, can you hear me?
I'm finally
back on camera after what, a year and a half? It's no biggie.
I haven't changed or
I haven't changed or anything.
Just popped out a kid.
You know,
Raising these babies.
How is everybody
doing?
Hey, Julia T.
Oh, is there echo? Hold on.
Oh, is there echo? Hold on. Okay.
What about now?
What about now?
Is the echo bad?
Is the echo bad?
Let me know.
Let me know.
Any better? Yay or nay?
Any better? Yay or nay?
OG mod.
OG mod.
So while I wait for that. Give me just two seconds
to pull something up,
and I'll be right.
Don't go back. Don't go anywhere.
Hey, Julia T. Sidebar. Give me just a second, guys, to fix my mic, and I'll be right back. I'm sorry. I don't know what's going on. Okay, is there an echo now? We do not need two of me speaking at the same time. I'm already rude enough. So if you could let me know in the chat, and then we could just get rolling. No echo? Oh, we're good. Okay, awesome.
Oh, we're good. Okay, awesome.
All right.
All right.
So camera's working.
Camera's working. Everything's good.
I had to move.
I had to move my studio
back into the
back into the old place that I used to
do my lives in.
do my lives in.
So
yeah,
the lighting was really
the lighting
terrible
was
in there,
really
so I just
terrible in
stopped
there,
doing
so
it.
I just
Plus,
stopped doing it. Plus,
who has time for
who
all
has
that when
time
you
for
have
all that when you have
babies running around?
around?
Oh, no. Okay,
No.
hold on.
Okay, hold on.
I tell ya.
What about now? What about now?
Good?
Good?
Testing.
Testing.
Any echo?
Any echo?
Okay, what about now?
Okay, what about now?
That should fix it.
That should fix it.
I just got a message
I just got a message from my OBS guru people person.
Okay, hold on.
Okay, hold on.
Damn it. Are we good? Is this better?
Is this better?
I'm just gonna go old
I'm
school
just gonna go old school
and use the mic as it is. How is that? Better? Then we can finally get rolling. Because I have a bone to pick with Miss Ma'am, Miss Beverly Cannone. I'm tired of her shit.
That's for sure.
So are we still echoing?
Gma, OG Ma.
I'm waiting for your
confirmation.
Okay. I bet you that fixed it. That one click. How about now? It was my fault. So now that the webcam's back, it has a microphone in it. Are we good? I bet you were good. Yeah? What a return. Okay, good. All right, so as everybody probably is already aware, in the Karen Reed case, there was a mistrial that Cannone, or Auntie Bev, decided without really any warning. It was just like, okay, we're declaring a mistrial. Let's get out of here. And I know, right? And the issue that I have, and I think everybody has, that's on at least Free Karen Reed's side, is that it looks very premeditated by the way that the motions were set up not only by the Commonwealth, but what Bev allowed and what she had how she had a part in that. For instance, making the jury basically gagged ordered with their names to keep them safe from intimidating Turtleboys of the world, right? Malarkey. We all know it's bullshit. It's because they didn't want the jury to squeal the truth. But at the end of the day, the jurors have a right to speak out, right? Within reason, I believe. So that's exactly what one of them did with Turtleboy. Now, before we get to that, I do want to go over the motion. And I forgot to go to Reddit to get it. If you go to like Karen Reed trial, the Reddit thread, they have all of that broken down, which is amazing. They have like transcripts and documents, and that's what I'm doing now is downloading it. So we're going to go through it. I know you love to hear me talk. I know that that's your favorite cup of tea because I put you to sleep half the time, but I think that this is very interesting. Here we go. We're just going to go right into it because obviously they didn't have a court hearing for this, so we have to just read it. Now, yes, the glare, everybody and their mama has come on and talked about this in Link today. Melanie Little did an amazing job, the glare, and I'm sure many others. But as you know, I have a little bit of a spin. I look into things a little bit deeper than just what, meets the eye. And we're just gonna get into it. Oh, thank you, OG moderator, my fave. Thank you so much. All right, Commonwealth versus Karen Reed. Decision order on defendant's motion to dismiss, which was filed today. Now, I wanted to go on Tom CPU this morning, but I had an appointment, and by the time I got back, the live was over. Aiden and the glare was on, and I was like, damn it! I had so many things that I wanted to add if I were there, but that's okay. But amazing live. Please go watch that if you have not. Tom CPU, their channel is Seeking Justice. That's the channel that they did the live on this morning. So amazing live. All right, so let's get into it. So the scroll out a little bit, sorry. This is just going over all of the nitty-gritty details that we all know about, and a summary that the defendant now moved to dismiss the charges for murder in the second degree and leaving the scene of personal injury and death, arguing that the retrial would violate the double jeopardy protections of the federal and state constitutions. So important. Double jeopardy. We have a constitutional right not to be tried twice for the same crime. Now, why do you think that happened? What was the decision constitutionally that created this, appeals upon appeals from a 100-year plus rule? Well, it's because people were being charged state and federal and state charges were being brought upon somebody, but they were basically being charged twice and serving time twice. So over the years, there has been many, many, many appeals being brought to the Supreme Court about that issue. Hi, Julia. Love you, girl, but I'm on the other side of the fence on this. It was on Yannetti and Jackson to speak up at the time. I would agree with you. Hey, Matt. Hey, Catfish. Hey, Daddy. Sorry, inside joke. Ignore that. You didn't hear it. Saying that, Matt, makes me want to hurl. I don't see how anybody else could do it, but I digress. Back on track. So people were having issues with being charged twice. Not to mention, think about this, if the prosecution fails to meet their burden of proof on you over and over and over and over, every time they can recharge you because they failed to do so, that's an issue, not only for your freedom and your liberty, your money, and the taxpayer having to pay for that. So double jeopardy is crucial, important, something that you want. You never want any judge or any case, you don't want that to be appealed later when they're convicted, because it does kind of trickle back into other cases. It could overturn cases that were rightfully, convicting someone. It's a mess. All right. And it's your constitutional right. You don't want to step on those toes. Thank you, Matt. Thank you. So, Julia, I love you, girl. Me and you were like this on the Michael Vaughn case and many other cases. I disagree that it was the defense's job to speak up at the time. She declared a mistrial, and that was that. What are you going to do if she declares a mistrial publicly, right, on the record? Did you want them to flip the table and say, no? Auntie Bev, have you been drinking too much? Wait a minute. And I think they pretty much immediately went to work on that. I mean, what do you do when a judge makes a ruling like that? It was pretty clear that she was trying to skirt around getting the defense to have any say, or anyone to have any say. So I think that it was very premeditated. From my understanding, judges in Texas anyway are held to a standard that you are to poll the jury if there is any potential for a acquittal or mistrial. You poll the jury if there's multiple charges or even one charge. So why didn't that happen? Well, you could kind of see it through the way that it was set up when jury deliberations began all the way until where we are now. I think it's very obvious to me. But Julia, I do appreciate that you feel differently, and I respect that. And if you have something that you can help me understand that when we're going through this, please do. Hey, Lenny. Thank you. Thank you. Mr. Eve, good to see you, love. Good to see you. All right. So she says, after careful consideration, this court concludes that because the defendant was not acquitted of any charges, and defense counsel consented to the court's declaration of a mistrial, which I have a hard time wrapping my head around, double jeopardy is not implicated by retrial of the defendant. The motion is therefore denied. Okay. Yeah, hello from the other room. Hey, Carrie, good to see you. Don't be starting no trouble in my chat unless it's funny. It's worth it. And if Magpie's in the chat, right? So the motion is therefore denied. So I have an issue with this. After careful consideration, or was it after making up my mind already? Joke's on you. The court concludes that because the defendant was not acquitted of any charges, and the defense counsel consented to the court's declaration of a mistrial, double jeopardy is not implicated. Well, the rules, you know me, I was like looking through all the rules of the courts. All right, specifically the district court, because that's where we were at the beginning of this trial, and then also all of the courts, appellate courts, like everything. I looked at all of the damn rules on this. So all you got to do is Google Massachusetts, policies, jury instruction. You could also look at our mass.gov. We'll just go to mass.gov. Public dispositions from the CJC is one of my favorite places to look, because that's the Commission on Judicial Conduct. That's where all the juice is, all the drama, all the bad apples in the judicial court system that likes to fuck around and find out. But let's look at mistrial. Let's type in mistrial. Criminal procedures. General laws. There it is. That's the word I was looking for earlier. So let's look at general laws. Let's look at the bare, like civil, all right? Civil laws, including criminal law. I'll see what happens. I don't know. What do they think about mistrials? What's the law? What's the regulation? Irregularities or defects causing mistrial or verdict to be set aside. Okay, let me just zoom in here. Whoa. Slow your roll, Eve. Okay. Any irregularity in compiling any list of jurors or prospective jurors, or any irregularity in qualifying, selecting, blah, 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 blah. Instructing. This is the biggest one right here. Any issues in that instructing of the juries, that's That's the whole reason for the issues. Hey, Jeep girl. if you're if you have any irregularities in how the jury comes to the courts and says, we don't know, help us out, right? This is what they say to do. Any procedure performed under this chapter shall not be sufficient to cause a mistrial or to set aside a verdict unless objection to such irregular, you know that word, or defect has been made as soon as possible after its discovery or after it should have been discovered, and unless the objecting party has been specifically injured or prejudiced thereby. So this is what they were saying, and this is what Julia T in the chat is saying, because they didn't bring it to the court's attention of this mistrial. It shall not be sufficient to cause it. Well, that's not what we're talking about. The argument that Julia is making in the chat and others is it didn't cause the mistrial. Those instructions that were confusing, first of all, Bev's changing of a few words that makes an entirely different set of circumstances when deliberating makes a difference. And that's what she did, in my opinion. And we're going to get into it. It's exactly what she did. It's those little things that you really can't cry too hard over, because judges have such discretion with these things, especially jury instructions, which blows my fucking mind. But it gives too much wiggle room for these judges to get away with shit and people be wrongfully convicted, or their conviction, which was proper, be overturned by the appeals process. So, like, it's a big deal. Like, make it cut and fucking dry here. All right? Excuse my language, but it gets really annoying. All right. So, it's not sufficient for a mistrial. She already declared the mistrial. So, this isn't stating anything after the fact that the mistrial was already declared. And in my opinion, if you're not polling the jury, if you are naming the charges as a verdict, not verdicts on the charges, the multiple, the lesser, why are we here? Like, you're reading things like it's all one big potato. You have to decide on everything or nothing, and that's the problem. That's the irregularity to me. But that's general law. Let's keep going. Special jury questions for first-degree murder. We'll skip that one because it's second degree. I think that's it. I think there was one more, though. Acquittal. There we go. Acquittal, effect on subsequent charges. A person shall not be held to answer on a second indictment or complaint for a crime of which he has been acquitted upon the facts and merits. But he may plead such acquittal and bar of any subsequent prosecution for the same crime, notwithstanding any defect in the form or substance of the indictment or complaint on which he was acquitted. Well, Karen Reed has not been acquitted of anything. She denied this. But she shall not be held to an answer on the second indictment or complaint for a crime of which they have been acquitted. And they knew that, meaning they cannot, Bev cannot rule in favor of dropping those two charges, because then the one that remains, the manslaughter charge, is going to stick. Or it's not going to stick. It's going to be appealable in itself. The burden of proof has completely changed. I mean, think about it. Second-degree murder is where they want the charge to go to with her. Of course, they want bare minimum those subsequent charges, the lesser included charges, to be the bare minimum, but they want that second-degree murder charge. If that goes away, they're fucked. They know she's never going to be convicted. Thank you, Nico. I appreciate it. Carrie says, I might actually watch the trial this time. I felt left out last time. Poor Carrie. We were talking about Karen Reed all day. She wasn't included in our convos. I hate when that happens, though. I get you, girl. I hate when I don't know the case facts and people are talking and it's very interesting sounding, but I have no fucking clue what's going on. I get you. Hey, J. Marie. All right. Violations of acquittal, dismissal, or indictment. No, no prosecute or something like that. Sealing of records. Acquittal on merits in district court. There was one more. And that's okay. It doesn't matter. Basically, it just says you need to count. You need to do poll the jury. Once you do that, mistrial all day long. She didn't do that. Bev didn't fucking do it. Just didn't. Just didn't. Poll of jury. When a verdict is returned and before the verdict is recorded, the jury may be polled in the discretion of the judge. What? The discretion of the judge. Now, I do understand if you have lesser included charges, right? For in this instance, second degree murder is the main charge, and then you have the manslaughter charges, leaving the scene, all that shit. All right. Well, if you tell them, let's poll and see where you're at, and they confirm that no one wanted second degree murder, right? It could cause, or somebody changes their mind last minute, it could cause a lot of strife. It would give the defense a little bit more than they should have, right? Or maybe somebody misunderstood. It could cause a lot of problems, so I do understand that part, that they don't want to poll too early. But at that point, they were at an impasse. The foreman said, and I quote, we are stuck in our convictions, stuck in our ways and our beliefs, which the Glare put up, stated a great point about that. What do you mean convictions? I agree. I'm trying to understand that too. You go based on the facts, not your belief system. You go by the evidence and if they prove their case. But they didn't. So if after the poll there is not a unanimous concurrence, the jury may be directed to retire for further deliberations or may be discharged. Now there's a whole ass report about however, there's some issues that we have seen in the past. The defense has mentioned these, Commonwealth versus Brown, using them as examples, which Beverly, you'll see in the denial of this motion to dismiss, lied her ass off because the defense did reference excellent cases, but she said that they didn't. And we're gonna prove you wrong, Beverly Cannone. Julia says that's what defendants have lawyers for, to point out those finer issues. Well, lawyers aren't perfect either. And if the judge is going to say, make you fight tooth and nail on every little thing, first of all, and then finally decides to randomly mistrial the whole case without doing their due diligence, going all the way, right, Julia? What else are you going to do if there is a mistrial? Mistrial means you're not in prison. You're not convicted of a crime. Why would you want to question that? It pigeonholes the defendant so hard that they don't have many choices, right? You're damned if you do and damned if you don't. I don't think it's right. I don't think it's a fair circumstance to be in, or for Bev to put her in. I think she did it on purpose. I think she did it absolutely 100% premeditated, right? And you don't know what you don't know. What if you can't psychically read the minds of the jurors, right? Or the judge. They didn't know that she was going to declare a mistrial. Had they have considered that it was coming, I'm sure that they would have jumped up and said something. They didn't know where she stood yet. They don't know. You don't know what you don't know. That's why you confer as a judge with your big girl voice and your big girl panties and say, sidebar, can we go to sidebar and get those lawyers up there and talk to them before you make that damn call? She jumped right on it on purpose. She knew better than that. That's just my opinion. Okay, background. Woo-wee. On June 25th of this year, the jury began its deliberations. In addition to the 3 indictments, the court has instructed the jury to consider 2 lesser included offenses to manslaughter while operating under the influence of alcohol, involuntary manslaughter, and motor vehicular homicide. And then a few days later, at 12:10, the jury foreperson, which I have a bone to pick, sent a note to the court. It stated, "I'm writing to inform you on behalf of the jury that despite our exhaustive review of the evidence and our diligence consideration of all disputed evidence, we have been unable to reach a unanimous verdict." Not verdicts, plural. Singular is here. Why? Because the jury was under the impression that they had to select not guilty or guilty on every single charge as one or else. We know this. This is it. I don't think it's even disputable at this point. It's been proven. The jury thought it was all or nothing, right? Right, OG? Right. Ridiculous to me. The court requested argument from the Commonwealth and the defendant as to whether there had been due and thorough deliberation from the jury. ADA Lally, on behalf of the Commonwealth, argued that the jury had not. We know what happened. Even said that the Tubi Rodriguez was too soon. Let's just let them go back and deliberate. You know, the word exhaustive is the word that I think is operative here. They only really have been deliberating for a few days. There's a lot of evidence in this case and exhibits, which there was. All right. So they just said, kick them back. Let them deliberate more. Yeah, it instructed the jury to continue deliberating. Then on Monday, July 1st at 10:45, the juror sent another note to this court. This note stated, quote, "Despite our commitment to the duty entrusted in us, we find ourselves deeply divided by fundamental differences in our opinions and state of mind. The divergence in our views are not rooted in a lack of understanding or effort, but deeply held convictions that each of us carry." Deeply held convictions. Let's act like we are 9 years old and we don't know what that means. But we're smart enough to go on the internet and look it up. What does the word, what does that mean? Deeply held convictions meaning. Is that even a legal term? And why is a jury foreperson using this kind of language like they're a lawyer? Doesn't it sound very lawyery to you? It does to me. A strong belief or opinion has deep convictions, the state of mind of a person who is sure that what he or she believes or says is true. So think about that, and without a doubt meaning. Convictions, beliefs, what you think you know based on what you believe, what your belief system is. Well, without a doubt, which is what you have to use when looking at the evidence and the facts of any charge, especially murder charges, the phrase "without a doubt" is used to emphasize that something is true or to indicate that there is no uncertainty about something. Like, you got to prove that. Well, we cannot believe or approve our belief systems or belief without a doubt. That's why there's so many of them, right? Or our convictions, right? So I would have thrown up my little red flag as a judge and said, well, hold on now. This isn't about that. So we need to go back and deliberate some more. I would tell them to go back and drop your fucking convictions and act like you don't know what that means for a minute and just look at the evidence and the facts and the charges. Reread those instructions. I'm 2 years old, right? Right? Yeah, so they were locking horns to the death. They were looking for any reason. We know it. We know it. So the court again requested argument from counsel as to whether there had been due and thorough deliberations. The Commonwealth argued that the jury had been deliberating 22 to 23 hours, but given the length of the trial, still not enough, right? You got to go back. But this time they, used the Tui Rodriguez. But Yannetti was like, no. I disagree. Our view is that it is time for, or he agreed, excuse me. He was the one that brought up the Tui Rodriguez. Our view is that it is time for Tui Rodriguez instruction. They have come back twice, indicating, essentially, that they're hopelessly deadlocked, but the content of the latest message is that they have been over all of the evidence. The previous message said they did an exhaustive review, meaning at its finality. This time they said that they have fundamental disagreements about what the evidence means. It is a matter of opinion. We don't work with opinions when it comes to convicting someone of murder or manslaughter of a Boston police officer. So it's a matter of opinion. It's not a matter of lack of understanding. This court, when you sent the jury out, encouraged them not to take a straw vote, which is a poll. Okay. And encourage them to go over all of the evidence in a very methodical manner. I think all indications are that they have done that. This is what Tui Rodriguez is for. The court agreed that the jury had engaged in due and thorough deliberations, noting that this jury had been extraordinary and had never seen a note like this from a jury. It thereafter provided the jury of the full Tui Rodriguez instruction and asked them to return to the deliberations with those instructions in mind. Right? So let me repeat this. When Yannetti was telling the judge, his thoughts on the Tui Rodriguez being read. This court, when you sent the jury out, encouraged them not to take a straw vote. Why? Why? Why wasn't that offered later on? Since you didn't offer it then, why didn't you offer it later when it mattered? Let's just look at Massachusetts straw votes. Criminal procedure. It's not called a straw vote. It's called, obviously, a jury poll. But in Massachusetts, a court may poll a jury after a verdict is returned to see if the jurors agree with the verdict. Of course, we know that. A jury can be polled at the request of a party or on the court's own motion. If a jury is polled and there is not a unanimous agreement, or if the verdict seems like a compromise, the court may consider other factors. Let's look at that lovely Rule 27 procedure. Let's specifically look at several offenses of the defendant. I have to delete that. I'll put those back up. So if there are two or more offenses of the defendants tried together, the jury may, with the consent of the judge at any time during its deliberations, return or be required by the judge to return a verdict or verdicts, plural, with respect to the defendants or charges as to which a verdict has been reached. Nothing was reached at all. That's why it was so important, in my opinion, to poll the jury, or at least ask where they're at. The judge may declare a mistrial as to any charges upon which the jury, let me repeat that, sorry. The judge may declare a mistrial as to any charges upon which the jury cannot agree upon a verdict, Provided, however, that the judge may first require the jury to return verdicts on those charges upon which the jury can agree, and direct that such verdicts be received and recorded. Right there. Rule 27. Where did she go wrong? I already proved on Twitter, or X, that Miss Beverly, in the 90s, already had this issue with jury instructions being confusing and assisted in the defense, other defense attorneys, because there were multiple, it was one crime or two charges that 5 men were involved in, of essaying and raping a woman who was mentally handicapped. So even she said the jury instructions were confusing and wanted an appeal. It's somewhere down here. So that was very interesting to me. As if she didn't know. She knew. She knew. I promise you she knew. So let me see if I can look it up. Oh, not fine. Sorry. Anyway, while I'm looking that up, it's like, you knew from the 90s onward. She is head of some of the departments there in Norfolk County and Suffolk County, where she sees these issues constantly. She's full of shit. Bev is full of shit. So anyway, we'll get back to that. So that same day after the Tui Rodriguez, at 2:30, the jury sent another note to the court. After the jurors filed into the courtroom, the court read the note. Despite our rigorous efforts, we continue to find ourselves at an impasse. Our perspectives on the evidence. What's perspective? What's the definition of perspective? Oh, shit. A perspective has multiple meanings, says Google AI. A way of understanding and thinking about something such as a life situation or issue. For example, she was being rude or candid is all a matter of perspective. She was being a raging bitch. Somebody else would think she was just expressing her feelings. Didn't make her a bitch, right? Come on. It's very simple. A person's perspective is shaped by their values, life experiences, and other factors. And it's their way of seeing the world. For example, I'd like to get someone else's perspective on this. The appearance of objects, the art of suggesting 3 dimensions, blah, 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 blah. Perspective. Meaning not unanimous at all. Perspectives rarely make a unanimous decision ever in life. So, problem. There will be a quiz at the end of this. Just kidding. So, lost my place. Our perspectives on the evidence are starkly divided. Some members of the jury firmly believe that the evidence surpasses the burden of proof, establishing the elements of charges beyond a reasonable doubt. Conversely, others find the evidence fails to meet this standard and does not sufficiently establish the necessary elements of the charges. Plural. The deep division is not due to a lack of effort or diligence, but rather a sincere adherence to our individual principles and moral convictions. To continue to deliberate. Moral convictions have nothing to do with this. Yeah, I'm glad you're back to Julia T. And no shame to Jeep. I don't think she, yeah. It's all good. It's all good. But moral convictions and your principles don't matter right now. You are just a human being that is looking at the evidence, looking at the charges and the elements of the crime. Are when you look at that, do you go, absolutely she did it, or absolutely no way in hell? It's really simple. So that whole moral conviction shit, I don't know why he said that. To continue to deliberate would be futile and only serve to force us to compromise these deeply held beliefs. Issues all over the place. I'd send them back and be like, stick those up your ass, those moral convictions in your belief system, and focus on the evidence. After reading this note, the court declared a mistrial and discharged the jury back to the deliberation room to wait for the judge. Counsel remained in the courtroom to discuss an agreeable date to return for a status conference. On July 8th, the defendant filed the instant motion to dismiss, supported by affidavits from Yannetti and Jackson. Because of the informant saying this is what was told to me, that got everything in motion to where we are now. Informant ABCD said juror ABC said this, that, and the other. Crisscross applesauce. You know what I'm saying. Or not. But at the end of the day, they were saying that they did get to a unanimous verdict on counts 1 and 3, being out of there. No way. Only the second charge of lesser included specifically leaving the scene. And they were still not, I think I heard 6 and 6 and then 9 and 3. I don't remember which one was the matter of fact answer on that, but still they were not in agreement on the lesser included charge. So again, no one was going to convict her. Not unanimously anyway, and that's all that matters. So, in his affidavit, Attorney Jackson stated neither Miss Reed nor her counsel consented to the entry of the mistrial. Defense counsel was denied the opportunity. That is a big one. It's a bold claim, Mr. Jackson from Texas. Yeehaw. He's saying, we were not given the opportunity to request that the court inquire on which counts or counts, plural, the jury may have on being deadlocked, including those lesser included offenses, and on which count or counts the jury may have arrived at a verdict. You could muck it all day long, but look, it's really simple. She did not do her due diligence with the issue at hand, and they were denied the opportunity to request that inquiry. But it's at the judge's discretion. Remember when we read earlier in the general rules of acquittals and mistrials, that those are kind of the guidelines at the discretion of the judge. So which one is it? Right? The law needs to be changed on this, or the rule book needs to have a specificity on this issue. You could go to the Supreme Judicial Court oral arguments right now. And there's about 5 in the last year alone of similar issues with different circumstances of the case. Criminal, where jury instructions, and jury deliberations, and then a conviction or a lesser included being dropped and a main charge being the conviction, is strictly because the judge did not do their due diligence. That it's there. I'll even show you one to listen to, because we're not going to go over like 3 hours of arguments or 30 minutes of arguments. We're just not. But you can go to Massachusetts Supreme Judicial Court right here, oral arguments, and there's a plethora of examples. Sincerely. And this is just Massachusetts. there's other states, that have the same issues, and they talk, right? And they're asking these appellate court judges or lawyers, what is your opinion on these other states that are doing this and that and the other? They're considering what other states are doing. So, and you can see where I have watched the ones that either are related to jury instruction issues or double jeopardy constitutional issues. And yeah, there's quite a few. So everyone that has a red all the way through, issues with jury instructions or judges' discretion of how they change the language in the instructions to the jury. So, Hey, there's Tom Bradle.
He comes in.
Tom Bradle is the attorney for Turtleboy. And he is a very good speaker, in my opinion.
Under the aggravated kidnapping statute.
Substantial, very substantial,
Whoops.
very imminent. Like
Mark
He
Betterow
comes in.
joined, by the way.
He's dressed in black.
Not in here, but if you don't know, he's a lawyer that's on YouTube that has expressed his side of things on the Karen Reed case, and I agree with him like 90% of the time. And he has joined the Turtleboy team.
Will spend the rest of his life, likely spend the rest of his life in prison over a statute that we're not quite sure what it means. And no one wants to be part of a system where someone...
Tell us what it means then. So,
Okay.
from what I understand, there are 3 levels of kidnapping.
Yes.
Why does it make sense that your client, because again, I look at the legislature, they're not a bunch of grammarians. They're focused on policy distinctions. So your client is armed with a gun, he kidnaps, and the result is death of the kidnapped victim. So why does it make sense that the injury basically doesn't matter at all here in your client's case? Is it all because of the word thereby?
It's a very fact-bound case, Your Honor. It's a convoluted set of facts. And
Again, the legislature's writing in categories. So I just want to understand why that is.
Sure.
'Cause, again, I don't find either of the 2 decisions below that helpful in elucidating meaning as opposed to grammar.
Sure. The answer, Judge, is found in a close review of the facts, the scope of the joint venture, Your Honors.
So this is an example of, the Supreme Judicial Court not giving a bleep about grammatical issues in the writings of these instructions. So you're going to need to bring some more than just grammatical issues. Because I do not believe that they did not rule in his favor. So that's important. This is important to look at how the Supreme Judicial Court and the District Appellate's Court, all of the appellate courts, view these issues that we're seeing in the Karen Reed case. I've done the work for you. So those videos are going to come out soon. But one example before we continue, which I have downloaded, is quite interesting. Let me look at my history. Sorry, give me just a second. Yep, there's my sign to just wait on that. I'll put it out in videos because it's so important. So very important. Here we go. Wait. History. Hold on. This is the one. Double Jeopardy Clause. Dinespi versus United States.
Him for aggravated sexual assault for the exact same event that led to his assault charge in the Court of Indian Offenses and was subsequently found guilty. He challenged his prosecution in federal court, arguing that it violated the Double Jeopardy Clause of the Constitution.
So they denied this motion, or this appeal. However, they changed the law of sovereignty, meaning 2 different sovereignties or countries or entities like the government and the state, right? Federal versus state, they changed the wording of the law. So this is the one that you should listen to if you want to, if you are feel so inclined. Just wanted to show you that. All right, we're gonna skip the nitty gritty. I cannot read juror A to B to C to D to A to B to E to whatever. I'm not doing it. They basically talked to each other and they agreed that they unanimously said she did not do second degree murder and then count 3. So blah, 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 blah. Attorney Yannetti later filed a supplemental affidavit saying all this shit. On July 10th, Jackson submitted a supplemental affidavit saying the same shit with some new information. And then the interesting thing is that, pisses me off. Adam Lally, ADA Lally, puts a memorandum way too late, by the way. Goes to the court and puts a memorandum in that says, hey, the jurors did reach out to us on like July something, and we emailed them back or called them back and said, we can't ethically talk to you, and even if we did, we'd have to dox your ass. We can't say that we're not going to basically expose who you are when this happens. And then they never responded. Pigeonholing them into not speaking about it anymore. And then we're like, oh, well, we're done here. That's what 88 Lally did. Mm-hmm. It's called the post-trial notice of disclosure. This is where I'm going to end the live with, because I do have to get off of here. But this is the most important and crucial part, in my opinion, about Auntie Bev and her confliction in this case. This is the proof. All right, let me go to my Twitter and pull up my latest tweet. I posted this today. How can the Commonwealth's post-trial disclosure be a finding in Bev's denial when Lally pigeonholed the jurors into silence? What do I mean by that? Now comes the Commonwealth in the above captioned matter and provides notice that on Sunday, July 21st, 2024, Assistant District Attorney Adam Lally received unsolicited voicemail on his office phone line from an individual who identified themselves as a juror by their name and seat number. The individual stated, it is true what has come out recently about the jury being unanimous on charges 1 and 3. On July 26th, which was 5 days later, ADA Lally received another voicemail who stated the same. The Commonwealth did not respond to this individual, as the Commonwealth is ethically prohibited from engaging in discussions about the jury's deliberations process. No, Lally. It's not about the jury deliberation process. It's what they're telling you is what happened in relation to the verdicts, plural, that they came to an agreement on. That is a completely different thing. Thank you, Brooke.